The matter before the court is BCD 2373, Eastern Maine Medical Center et al. Versus Teva Pharmaceuticals et al. We are being streamed live on the web, both by video as well as the usual audio. If counsel are ready to proceed, what I would ask is that counsel who are arguing introduce themselves by saying their names for the record together with the party you represent.
Please the court, Your Honor, Daniel Charest on behalf of the hospital plaintiffs, the Eastern Maine Medical Center, the Aroostook Medical Center, the Blue Hill Memorial Hospital, Charles A. Dean Memorial Hospital, the Inland Hospital, Maine Coast Regional Health Facilities, Mercy Hospital, MRH Corp., and Sebasticook Valley Health.
And for appellees.
Your Honor, William Murphy, and for purposes of this appeal, I'm representing all of the appellees.
Thank you. Mr. Charest, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Madam Chief Justice. May it please the court. This nation is suffering from an epidemic of opioid addiction because these defendants flooded the land with more pills than any legitimate use would require. They did it on purpose, they did it pursuant to a plan, and the plan worked. Pills flowed and profits soared. And within this national crisis, Maine as a state is suffering more than other states. As individuals, as human beings, we each have personal and all too very real touches with this opioid epidemic. It could be friends, family, neighbors. We've all felt it to some degree. But hospitals are different than individuals or the general public. Hospitals suffered uniquely as a result of the opioid epidemic. In Maine, like other states, hospitals are required by law to provide care and by morals to provide care. Hospitals have been providing essential care to the population of Maine throughout this entire opioid epidemic. And fundamentally, the hospitals have been left to clean up the mess created and left behind by these defendants. Year over year, hospitals incur staggering costs as a direct result of opioid addiction. Opioid users stay longer, they require more procedures, they encounter more complications, they cost more money to treat. Those are fundamental, actual harms to the hospitals that are doing the treatment. And that economic harm hurts Maine hospitals even more because, like the plaintiffs at bar, most of them are rural, nonprofit hospitals struggling to provide services to the communities that need them. By dismissing the case, the court below absolved the defendants' actions and barred all these hospitals from any relief whatsoever. This court should reverse and allow this case to proceed like so many other cases against these same opioid defendants by hospitals across the country. I'm going to start with a discussion about nuisance. There are two key points around nuisance. Number one, is it a public right? Number two, is there a special injury? We cited State v. Hull for the notion that the public right...
Well, you said many courts, so I'd just like to get straight. By my count, there have been two highest Supreme Court states that have dealt with this or similar issue, Oklahoma and Arizona, and they both said no. Is my count wrong when we're focusing on state Supreme Courts? What would you say is your best authority from another state Supreme Court?
The Alabama Supreme Court recently denied mandamus petitions in the case that's set for trial in July of this year. That happened, I don't know, a month or two ago, maybe 3 months ago. And the reality is most of these cases have succeeded on motion to dismiss and are in the trial courts working their way up. So it's an improper measure to say, oh, the only state Supreme Court cases, because by virtue of the fact that they go to trial, they succeed over motion to dismiss, which is what we're dealing with here, and they proceed to trial on the merits, some win, some lose, but they go forward. Looking at that small sample set doesn't really answer the question. But my understanding, I know for a fact that Alabama recently denied mandamus petitions because I'm involved in that case as well.
Do you wish to speak to the aspect of the dismissal that related to the pleadings as being prolix
Yeah, so that's yes, indeed. The court, well, I say it this way.
Do you agree that it wasn't a short and plain description?
The petition is not short and plain, but neither is the conspiracy. I mean, this is a national level conspiracy that happened over years, in which the defendants manipulated medical standards, hospital accreditation standards, regulations, and floated false narratives out there. And we have thousands of paragraphs, we had I think it's 1,540 something paragraphs talking about it, and the court accepted 70 of them. But then turned around and said, in particular with fraud, oh, you haven't shown anything. So it's on, you know, on one hand, we as plaintiffs have learned in the post-Iqbal and Twombly life to be very specific.
So would you reword your claims if you had the opportunity to amend?
Absolutely. We asked for the opportunity.
In what way would you, what changes would you make?
Well, specifically, I mean, I guess I might go in less detail, frankly, of what the allegations are. I mean, we walked through this Scylla and Charybdis of oh, that's too conclusory. Well, that's too much detail. And, you know, that's a hard, you know, like, you know, on a pleading standard, the real question on pleadings.
But the real issue here was that although there were many, many, many allegations, most of them had to do with what's happened on a national level and really didn't have anything specific to do with the claims that the hospitals in Maine have asserted. I mean, isn't that real? That's where the specificity was lacking, despite the thousands of paragraphs.
Well, it is true that the argument, that the discussion about the conspiracy was at a national level, but that's because the conspiracy was at a national level with effects throughout the country and in particular in Maine. And so it's not, the standard is not what set of facts that happened in Maine can lead you to recover. It's what set of facts, period. And if and they did, the defendants conspire outside the state of Maine, and it has an effect, a foreseeable effect as a result of an unreasonable
We're going to
arrest
talk
in
about
Maine.
the merits. We're going to jump into the merits in just
Sure.
a moment. But are you seeking an opportunity to amend? Are you, if we accept the court's conclusion that it was prolix?
Yes.
And just to build on that, to be clear, federal courts have actually dismissed claims on that basis under Rule 8. We haven't done that. And I'm not sure that that's what was done here, but it certainly is an issue. So go ahead and address the question.
I've never been involved in a case that's done that. It would be pretty striking to me because, again, like the modern trend in these larger cases is to stack the complaint full because of the Iqbal.
It may be the
Twombly.
trend by the plaintiffs, doesn't mean it's a good one, but go ahead.
I don't like it either, to be honest. You know, because
So you want the opportunity to amend?
Yes, sir.
And can you talk about proximate cause?
Sure.
I'm trying to follow the chain here, an uninterrupted chain between the act and the claimed damage.
Absolutely. So on proximate cause, the ruling by the trial court was that there were too many intervening causes and events. What the trial court didn't appreciate or didn't credit, and those are in the part of the complaint that he didn't read or listen to, is that the defendants had their hand in every one of those steps. The defendants manipulated medical standards in order to encourage doctors to prescribe more opioids. The defendants manipulated hospital accreditation standards to make the hospitals allow more opioid products because that drove whether or not they're going to be accredited. The defendants floated false narratives about the qualities of opioids, and so all of their aims were to flood and supersaturate the market with opioids. The necessary result of that, the foreseeable result of that, is an opioid crisis, an opioid epidemic, which we have. And then when you have that, the foreseeable result from there is that hospitals who are left to clean up that mess will suffer the consequence of it.
But isn't this more of a products liability case than a public nuisance case?
Not at all, sir.
We're talking about products, not a cloud of toxic gas or something of that nature.
It really is more like a toxic gas than the products. The products work. The products they stop pain, but they're also massively addictive. This is not it's not a failure to warn kind of claim vis-a-vis the users of it.
But your claim is that they're unreasonably dangerous, isn't it?
They are unreasonably dangerous, yes, sir.
In the nature of a products liability claim.
As to the user of it, the one that uses the product, they may have a claim. But this is like I go to Tamano for the notion of the oil spill in the Casco Bay, or the State v. Hall where the offal in the street. The idea is there is this mess, this problem, this thing that is created by an identifiable class of defendants that affects the public good. And then the question is, are you, the hospitals, do you have a special injury or not? Are you like every one of us who has some sort of connection with the opioid crisis? Or are you like the fishermen and clammers in the Toronto case, which the court below didn't even address, where you either have to fish in oil-ridden waters and incur more cost, or have suffer specific compound and focus damages, or are you like the shopkeepers in Old Orchard Beach, who maybe there's an effect, but not a direct effect? And the reality is, and again, we're talking about what's real. What's been pled for sure is that the hospitals are exactly that.
Well, can I take you to the fraud claim and the specificity requirement? Can you just take one example of a specific statement made by one of the defendants, the time and the place that they said it, which defendant they said it to, and how it was actually and justifiably relied upon?
Yes. The best example I have with respect to the fraud claim is this. There is an outfit called the Joint Commission on Accreditation of Hospitals. We call it JCO, or the Joint Commission over time. JCO received millions of dollars in support from these defendants, and in return opened up their books and allowed these defendants, not their medical wing, but their marketing wing, to alter the standards that drive the commission, that drive the accreditation standards for hospitals. So these are the standards that are set out that tell you how you're going to be accredited. Their marketing department were the ones that had the pen that affected messages that went to the hospitals about what you need to do. And you'll be surprised to find out that their pen wrote, you need to prescribe more opioids. You need to address pain more specifically.
Can I interrupt you on that? I mean,
Yes, sir.
these are trained physicians. They're the ones who have the authority to prescribe. It's no secret that opioids are addictive and it causes terrible problems. So if a motorcycle manufacturer put out a product with a plastic drive chain, anybody selling said, that thing's going to fail. That's never going to, that's a terrible idea to use that. Why isn't that the same as the physician saying, I know this is addictive, and I'm going to prescribe so-and-so milligrams to this person for months on months? Isn't that an intervening event in the chain of events?
So there's two parts there. I'll try and answer it both. Number one, on the intervening events or not, at the pleading stage, which is where we are, you have to trust what we say. You have to believe what we say, and you can, they may have defenses, they may raise them later, but the notion of intervening cause is not a superseding cause. And a superseding cause is something that they have to plead and prove, and the court below accepted their view of the world about intervening causes, treated them like superseding causes, and said that broke the chain of causation. Our argument and our pleadings say that every step along the chain of causation is foreseeable to the next and controlled by them.
But
And
can
that's
I
where we
return
are.
to what you said about it? Let's assume that that's in there, that JCO changed the standards, said hospitals, you should be prescribing more opioids. How is it that the plaintiffs in this case relied on that statement to their detriment?
Because they have to. They have to become accredited. You must follow these standards. And so, in the way it manifests.
So what your claim is we prescribed too many opioids, and by virtue of us prescribing too many opioids, we were damaged?
No. When you look at the numbers, the question is on the fraud claim. There is an obvious and unbroken chain between their false statements to the regulators.
Well,
of
it's not
hospitals.
so obvious to me, so maybe.
Well, I've seen the documents, right? I mean, but again, we're in the pleading stage. You have to trust me on this
I understand.
That's a credential-
I'm still trying to assume that that's all true, that they made these statements and that JCO therefore adopted these standards that said hospitals should prescribe more opioids. I'm still trying to understand how the plaintiffs in this case relied on that to their detriment and therefore incurred the damages that you're claiming were incurred. And you may answer.
Thank you, ma'am. And so the answer is, when you look at opioid prescriptions writ large, when you're looking just at hospitals, their percentages are like, I think it's less than 1% on the overall national amount. So they allow, not just prescribe, but allowed the prescription. Because remember, mostly it's not hospitals that do the prescribing, it's the doctors.
That's why I'm struggling with this.
Right, but they allowed, the oversight of the prescriptions, the oversight of the use of opioids was driven by the standards to not be as tight as it should be. And doctors, to answer Justice Meade's question before, Now we all know for sure that opioids are not addictive, are addictive. But when they came out, when this massive bust happened, these defendants were out there telling all the doctors that would listen that they are not addictive. They're better than other pain treatments. That is the fundamental nature of the misinformation that they put forward. Thank you.
Thank you. Mr. Murphy?
Thank you, Chief Justice. May it please the court, I'm William Murphy for the appellees. Counsel indicated that hospitals are different, and I agree, hospitals are different. And they're different primarily in this respect. A plaintiff who complained of harm flowing merely from the misfortunes visited upon a third person by the defendant's acts was generally said to stand at too remote a distance to recover. That's language from the Supreme Court's opinion in Holmes versus SIPC, S-I-P-C. It's quoting Sutherland on damages from 1882. It's Justice Souter's analysis of proximate cause. In Anthony versus Slade in Massachusetts in 1846, the person who had agreed with the town to take care of all the town's paupers was claiming that he was injured because someone assaulted one of the paupers, causing this contracting caregiver to incur more cost than he anticipated. The court said there's no such claim. That was an injury to a third person. It had a derivative impact on you, but you can't bring a claim in tort. Whether it's analyzed as either an issue of proximate cause or of duty, there is no duty on the part of these defendants that was owed to the hospitals that would result in the defendants being liable for the cost that the hospitals claim that they incurred as a result of the opioid crisis. Now, with respect to the plaintiff's request to amend their complaint, our position is it was waived under your decision in McAfee versus Cole from 1994. Analogy is exactly on point. A plaintiff lost his case on the statute of limitations. He then said, I'd like to amend my complaint to bring a different theory of why there was an exception to limitations. But he did not file a motion seeking leave to amend. Instead, he filed a notice of appeal. And in this court held, well, you've waived that issue because you did not present it to the trial judge. And in the same way in this case, on page 109 of their opposition brief to the motions to dismiss, they made brief reference to an opportunity to amend. But they never asked the judge for that opportunity, and they didn't file such a motion to amend. So they've waived it under McAfee. I would like to start on this.
Indicated that the defendant did not owe any direct duty to the hospitals. Is there a better argument that the defendants owed some sort of duty to the consumers of these products?
Well, perhaps so, Your Honor.
And if the hospitals paid the medical bills for those people, do they move into their shoes under subrogation?
No, Your Honor, and there is no such common law right of subrogation. In fact, that's part of what the Supreme Court held in Holmes, and it's analogous to every case that was brought by plaintiffs' attorneys on behalf of hospitals when they were suing the tobacco companies. There were, I think, dozens of cases, and every appellate decision in the federal courts threw out those claims, saying that there is no such duty for the hospitals to pick up the cost that the hospitals were incurring by treating cancer patients. Sometimes those costs were not reimbursed by health insurance. Those claims were all dismissed.
Well, the hospitals are alleging that they have a duty to provide care.
They do. They do have a duty to provide care. And that's their duty, and that's a federal statutory obligation under EMITLA. There's a statute that requires that the hospital can't turn away a patient who comes who's in distress. But that doesn't mean that someone who caused that distress is responsible for the hospital's cost. It would be like if there was a car accident and the person comes in with terrible injuries, he has no insurance, the hospital treats him, the hospital can't turn around and sue the negligent driver who caused the injuries to the patient.
Actually, our case law suggests that the hospital in that scenario would step into the shoes of the injured plaintiff and could pursue a subrogation action against the negligent driver.
Because there's a statute that provides for the lien in that case. and that's an exception to the common law. There is no such statute in this situation that applies. I wanted to talk a little bit about public nuisance. Our position is that this is not a proper nuisance claim for multiple reasons. First of all, public health is too amorphous a concept to give rise to a nuisance claim. The traditional nuisance claims, as this court knows, has to do with interference with the public highways, with natural resources.
Well, we have some nuisance claims involving, the discharge of offal. How is this any different than that?
Well, it is different because when the offal was discharged, it was on the streets of Portland, and it caused noxious atmosphere.
Are the opioids essentially on the streets of every Maine village and town?
It's different, Your Honor. There's not a common right that the public has a right to enjoy. When the streets were fouled, there was a common right that was being disturbed. Everybody who was in proximity was breathing noxious fumes. The opioid crisis is different. It applied to lots of people, but there were individual people who got addicted. It was not something that the whole community was suffering.
The harm was to society, to the families of these people, and to governments that had to pay the costs of treatment and, in some cases, incarceration, et cetera. Why? I suggest that this is a product liability case, but when the defective product causes harm to a neighborhood, like a defectively installed propane furnace, and it leaks over the neighborhood, doesn't that convert what would be a product liability claim into something closer to a public nuisance?
I don't know about the propane issue, Your Honor, but there's another reason why this is not a public nuisance claim. Actually, two other reasons. One is the Restatement 3rd, Section 8, says that it would always be inappropriate to base a nuisance claim on the sale of a product, particularly a product like a pharmaceutical product that's regulated. It's lawful to be sold. These products have benefits. They are effective painkillers when properly used. It would be wrong to use public nuisance to override the concepts that are inherent in a product's liability claim, such as the learned intermediary doctrine, where the doctor has prescribed.
Is your point here that the fact that the injured parties here were a distinct class of people who use the opioids, as opposed to the public in general, that's the tipping point, the portal?
That's part of it. That's why it's not a public right that's at issue. But the second part of it is that the hospitals have not suffered a specialized injury with respect to that problem. The hospitals didn't suffer from effects on their health. This is not a case where,
Well, but they're claiming a monetary, but I think to your point, if they can claim that as a special injury, so can many other providers, towns, governmental
not just
entities.
providers and towns, but the employers who lost their employees, the banks where they had the borrower default on the mortgage because they became addicted. I mean, it would override all of the law of negligence if public nuisance were given this broad effect. And that's what the restatement says and warns against.
Is part of your opposition to the amendment the fact that there really is no fact that they can plead on these particular causes of action? They could come back again, but the same argument you would be making when they came back.
I think essentially that's right. These are legal issues involving duty, proximate cause, and the proper scope of the nuisance doctrine. It's also, whether they have to allege a specific statement for a fraud claim, which they haven't done. And in response to Your Honor's questions, they didn't identify who made those statements. They didn't identify how the plaintiff hospitals relied on them. They haven't satisfied the basic elements of fraud. This is not an unjust enrichment claim. The benefits that the hospitals provided, they provided to the patients. They didn't provide those benefits to the defendants in this case.
How do you explain that there are a number of courts that have found, at least at the initial pleading level, like the multi-district litigation in Ohio, where do they go wrong?
I think they go wrong by not treating these as legal issues that can be decided at the outset. The Restatement 3rd, Section 7 talks about the idea that the duty that's involved when there's a third party that's claiming injuries that was suffered by someone else and they're claiming derivative injuries, that's an issue of law that ought to be decided by the court, and it can be decided at the outset. The same with respect to the public nuisance doctrine. That's where those courts ran off the rails. There are a number of other courts which we've cited which granted motions to dismiss, and as Your Honor pointed out, there are only 2 Supreme Courts of states that have reached these issues. In Oklahoma, the court, in a very persuasive opinion, Hunter versus Johnson & Johnson, decided that public nuisance doctrine does not apply to the opioid defendants. And in the state of Arizona, in the Boswick case, the court decided that hospitals have no claim against the opioid defendants for the cost that the hospitals are incurring in treating their patients for a number of different reasons.
Does it make a difference that they're not suing the manufacturers, they're suing the marketers and the distributors down the chain? They're a little bit down the chain, aren't they?
Well, actually, in this case, they have sued the manufacturers. They refer to them as marketers, but they are manufacturers. So they have sued manufacturers, marketers, distributors, and pharmacies all in one big lump. And there are differences, obviously, between them, but for purposes of this case, the legal issues are the same. Are these hospitals able to claim recovery for their cost against strangers to the relationship between the hospital and the patient?
What about their reference to JCO and hospital accreditations?
Well, I think as the court began to explore, I don't really understand that claim. If they wanted to bring a claim that said we purchased and prescribed too many opioids because we were misled by something, then that's not this complaint. They're not saying, oh, we got too many opioids into our pharmacies at the hospital and we prescribed too many of them. Because when they prescribed those for those patients, they were paid for that. They don't just keep opioids, locked up in the back and they have some value. I mean, they only have value to the hospital when they make a prescription and the patient or the patient's insurance company pays for it and they make a profit. That is not the claim that they're bringing in this case. They throw it into their complaint, I think in paragraph 602, that they bought more opioids than they should have. But there's no way that makes any sense. If that's the claim they want to bring, let them bring it.
Well,
that's not
I think they were saying there was some kind of impact on their accreditation. Did you understand that claim?
I think what the argument is that in the accreditation process, the institutions were being told you should treat patients for their pain. You should take pain seriously. I don't really know how that leads to a claim that for those patients who became addicted, we have some sort of right of action against the manufacturers or whoever else may have talked to the accreditation people about the need to treat pain more seriously. I mean, after all, there would have been physicians making assertions to that. There have been other groups making assertions to that. The pharmacies didn't do that. I mean, there's no, the plaintiffs try to lump everybody together and say, oh, everybody did everything. That's not true. And so there's no specificity to that claim.
So before Justice Connor's question, you were suggesting that if there was a particular claim they wanted to bring, let them bring it. With our jurisprudence of giving leave liberally to allow them the opportunity to now correct the mistake that the trial court saw in the way that they pled, they did put the issue before the court. Why would we not grant them the leave to perfect their complaint?
Because fundamentally, Your Honor, what they're seeking in this case is the recovery of the cost of treating patients. They are not, in this case, seeking to be compensated in some way for buying too many opioids. And if they were, let them bring that case, and then we will have discovery as to how much they were paid for the opioids they bought. And I think we'd be able to prove that there's no loss because they made a profit. That's not this case. So if they want to bring such a lawsuit, they should bring that lawsuit. But that's not a lawsuit that they want to bring because it's not a lawsuit that makes any sense for them. I wanted to mention a little bit more unjust enrichment because I think the elements are clear under Maine law that there has to be a benefit conferred on the party defendant by the plaintiff. That's absent in this case. There's also an absence of an equitable situation in which there's an expectation that the defendant has accepted this benefit with knowledge and has knowledge that he ought to pay for it. That's just not part of this situation. There was no expectation on either side when these hospitals treated their patients that somehow the manufacturers and the distributors and the pharmacies should pay for that. There's just no reasonable expectation
Well,
of that.
I think I see the unjust enrichment claim as kind of shading into the subrogation area that we talked about. Their argument seems to be that they covered a cost of treatment that was the responsibility of the defendants, and therefore the defendants were unjustly enriched.
But again, Your Honor, my understanding of Maine law, and I'm not a Maine lawyer, but my understanding is that there is a medical lien statute that allows you to step into the shoes of the plaintiff to recover when the plaintiff recovers from the person that harmed him. But that statute does not cover this situation.
Thank you, counsel.
Thank you, Your Honor.
I'm going to start on the point of this notion of third parties and negligence through third parties. This is not that case. The allegation is not that there's this duty on behalf of the defendants to take care of third parties. We don't say we're
But
third
how is
party.
there a duty on behalf of the defendants to the plaintiffs in this case?
Well, I'll cite the court to Mastriano, when it talks about the special relationship that the trial court poured us out on and that they've been arguing. And it says, yes, that's right, there's no absent special relationship, there's no duty. And then the quote goes on, unless the dangerous situation was created by the defendants. When the the situation was created by the
When a
defendants.
defendant creates a dangerous situation, that does not thereby mean they have a duty to everybody who might encounter it.
That's correct. It has a duty to those who are foreseeably harmed by it.
And foreseeability is reasonable foreseeability.
Correct.
You don't have to look any further than the bystander infliction of emotional distress cases to see that there are limits. We've
Yes.
permitted that claim to be made by those reasonably close who directly perceive it, but not by others, even though it may be very foreseeable that others would be distressed.
Well, that is the nature of that particular tort, I agree. But when you're talking about foreseeability at common law, the two factors I just said are exactly what the Maine common law says.
But that's the reason for that tort is that we have said that that's not what we consider to be reasonably foreseeable.
Because of the conversion in that case of emotional distress as opposed to physical harm. That's why there's that limitation, because the emotional distress requires a proximity.
Well, there's no physical harm here to the plaintiffs either.
That's correct.
It's pecuniary and economic.
They are correct. That's exactly right. But the other part of Mastriano that I'll point to is, well, again, from this court, when we talk of duty, we often discuss one's obligation to, and there's a list, it ends with, otherwise conduct ourselves or our businesses in ways that do not cause injury to others. They caused injury.
So what you're saying is absolute liability.
No, not absolute. They caused injury. No, it's still governed by foreseeability. But is it foreseeable that if these defendants create an opioid epidemic, that the hospitals who are required to provide care will incur additional costs? We allege, yes, we're at the plate with the allegations, and that is unbroken according to the allegations.
Thank you, counsel.
Yes, ma'am.
Thank you, everybody, for your arguments in this case. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter.
All right.